attorney Laura Anthony, founding partner of Legal End Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation of a Lawcast series discussing Rule 506 of Regulation D, including the difference between a traditional 506B offering and a 506C offering that allows for general solicitation and advertising. In prior Lawcasts in this series, I have been drilling down on the question of what constitutes general solicitation and advertising for purposes of determining whether particular solicitations would require a company to rely on Rule 506C as opposed to 506B in connection with their offering. Today I'm going to backtrack a little and explain the overall high-level 506C exemption. A Rule 506C offering has no limit on the offering amount, no limit on the number of investors as long as they are all accredited, and moreover, there is no limit on the number of 506C offerings a company can engage in. A company can even engage in ongoing perpetual 506C offerings for years at a time. In a 506C offering, the company or persons acting on the company's behalf, such as a broker-dealer or registered investment advisor, may engage in general solicitation and advertising of an offering as long as sales are strictly limited to accredited investors. Moreover, the company must take extra reasonable steps to verify the investor's accredited status. In a future Lawcast in this series, I'm going to talk about what those steps could be. The investor, however, cannot merely check a box or self-verify. In addition, all conditions of Rules 501 and 502A and D must be satisfied in a Rule 506C offering. Rule 501 is the definitions section of Regulation D and includes a definition of accredited investors. Rule 502D provides that securities sold in a Regulation D offering are restricted under Rule 144. Now, Rule 502A is important. It's an integration rule. Basically, where two or more offerings are integrated, all the requirements to satisfy the exemption for each of those integrated offerings must be met, or the exemption could be lost for both. For example, a Rule 504 offering is limited to $1 million in any 12-month period. It does allow for solicitation, and it does not require that investors be accredited. Whereas a Rule 506C offering has no dollar limit, also allows for solicitation, but is strictly limited to accredited investors. If a company completed a Rule 504 and 506 offering right after each other and they were deemed integrated, both exemptions would likely be lost and a rescission would be required. That is because if the Rule 506C offering was integrated with the Rule 504 offering, the dollar amount would exceed the $1 million allowed for the 504, so the 504 exemption would be lost. And there would likely be unaccredited investors because Rule 504 allows for unaccredited investors, so the 506 exemption would be lost, and so both would be destroyed. The same integration principle and issue could exist if there was an integration of a 506B offering that doesn't allow for general solicitation and advertising and allows for up to 35 unaccredited investors, and the 506C offering, which, as mentioned many times, is strictly limited to accredited investors and does allow for general solicitation and advertising. To assist in analyzing the integration issue, Rule 502A provides a strict 6-month safe harbor from integration for successive Regulation D offerings. So if 6 months has passed, you're set. There is also, and the rule sets out, a 5-factor test. It's a facts and circumstances test to analyze and be used in determining integration when the 6-month rule is not available. The 5 factors include an analysis of 1, are the offerings part of a single plan of financing? 2, do the offerings involve the issuance of the same class of securities? 3, are the offerings made at or about the same time? 4, will the company receive the same type of consideration in the offerings, such as employee services versus cash? And last, 5, are the offerings made for the same general purpose or same use of proceeds? I'm securities attorney Laura Anthony, founding partner of Legal and Compliance. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.